All right, let's go to this conversation now. The Western Cape High Court has made a significant ruling that several provisions of the Refugees Act are inconsistent with the Constitution. The ruling centered around the rights of asylum seekers and South Africa's international legal obligations, especially when it comes to sending back individuals back home who may be at risk of persecution or even serious harm. Let's get reaction and speak about the steps now that are to be taken as far as this case is concerned. We speak to the head of Refugee and Migrant Rights Law Clinic in Johannesburg. That is Carol Lemekwana, who's joining us live now. Carol, good evening to you and thank you so much for your time. Let's just start first with, of course it's a significant ruling. What is your reaction to it?
Thank you very much. Good evening to you and good evening to the viewers at home. As lawyers for human rights, we are very happy about the ruling, the judgment that was handed down. However, there is still, a bit of the fact that the interim order has now been set aside, so meaning that refugees and asylum seekers would still be arrested while waiting for their applications for refugee status to be processed by Home Affairs. So I think what I can say is that there is a mixed reaction. Yes, we are happy about the judgment, but as well still worried about people on the ground who are unable to access the asylum system.
Yeah, and I'm going to get to that, to some of the provisions in just a moment. But I want to stay with, the risk that they currently still are in. And you've touched on it a little bit. How long, is this likely to go on for, given the fact that right now they still are at risk, as you say, and there's still these legal matters that must be ironed out?
Yeah, for now we can say that, we can't really put time frame on it. However, as, we might be aware, as soon as a high court hands down a judgment that talks about constitutional invalidity, we have to take that matter to the Constitutional Court for the Constitutional Court to now declare those sections invalid. So therefore, now what we are currently doing, and which we are trying our best to make sure that this process goes on at a very speedy pace, is that we are trying to take this matter to the Constitutional Court to have the Constitutional Court confirm this judgment for us. So therefore now we cannot really say how long it will take, but we still anticipate people being arrested. We still anticipate genuine asylum seekers, people who have fled from your Eastern DRC, fled from places like your Somalia, where they are being killed, still being either deported or even arrested and not being able to access the asylum system.
Yeah, and when you go through the ruling, as you say, I mean, what you touch on, of course, is the important part around the Constitution and how, this particular ruling, even in the order, needs to be confirmed by the Constitutional Court. But I want to go to the sections of the Act that, this ruling does speak about, and even the case itself does talk about. For example, you look at Section, 4 on the exclusion from the refugee status. They speak about when an asylum seeker may not qualify for refugee status. It includes a commission of an offence with regards to fraudulent possession of some of the documentation, failure to report to a refugee reception office, among others. And when you're looking at these particular sections, there was this argument by some that it does look like there is a lot more power that possibly is given to the refugee status determination officer. Is that the case in your view?
Yeah, there is power, and I think what our argument has always been was not even on the refugee status determination officer, but the fact that people could not even go to that interview with the refugee status determination officer. So what this meant was that if, let's say, a person is, considered to have entered the country not using the regular route, then what would be done is that they would be subjected to a good cause interview, meaning that they would be interviewed by an immigration officer first to declare whether they have good cause. You spoke about issues of documentation and all that. So the purpose of that interview with the immigration officer was to check all that and challenge it. So if someone is found to not have good cause, then they would then be arrested and not even have an opportunity to speak to the refugee reception officer to speak about what their claim is, why they fled their country of origin and came to South Africa. So I think for us that was the biggest issue, because in terms of international law and the international protection, what it means is that so we look at the principle of non-refoulement, which prohibits people from being returned back to a place where they will face harm. So if someone is now subjected to a good cause interview because of those specific things that the immigration officer would see, or then it means that they do not have access to the asylum system.
Yeah.
So what we are fighting for as Lawyers for Human Rights and Scalabrini, what the biggest fight was that people should have a fair chance of stating what their asylum claim is, and after that interview, then the rest would then be would have to be dealt with after someone is able to get documentations to be in the country.
And especially because when you look at previous case law, the issue of discretion is quite huge in the legal system. But I wonder then, Carol, what happens if the Constitutional Court does not confirm this?
Yeah, that's a very good question. So if the Constitutional Court does not confirm this order, then it means that it's a setback for us. But what we are ready to do is just to continue fighting for the rights of asylum seekers and refugees, especially because most of them, what we are seeing in our law clinics on a daily basis is that most of them, they are genuine refugees and asylum seekers, and the issue of them not being able to access the system is a setback to South Africa at large as well, because we see all around we see people talking about undocumented people and all that, and people being arrested because they do not have documentation. And the worry for us is that these people genuinely want to get documents within the country, but the system is stopping them from doing that. So what we will do as Lawyers for Human Rights and Scalabrini is to try to keep on fighting for the rights of asylum seekers and refugees, to ensure that at least they also have a better chance of having their case heard and having a legal stay in the country, because I think it means a lot to most of our clients to have a legal stay within the country.
And Carol, let's see then what happens going forward. And as you say, that the risk still, is very much alive at this particular moment. But let's see what becomes the next steps in this particular process. I appreciate your time this evening. That was the head of a Refugee and Migrant Rights Law Clinic in Johannesburg. That is Carol Lemekwana.